All right, come to order. This is case number 20-1104, Maumee Indian Nation versus Wendat Band of Huron Indians. Petitioner, please announce your presence for the record.
We're here, Your Honor.
All right, is counsel prepared and ready?
Yes, Your Honor.
Respondents, please announce your presence for the record.
We are here, Your Honor, and ready to proceed.
Thank you. There has been an allotment of time made, and so please proceed, petitioner. Counsel number one.
Thank you. Good evening, Your Honors, and may it please the court. My name is Polina Noskova, and together with my co-counsel, Eric Ralston, we represent the petitioner in this case, the Maumee Nation. Today, I will be arguing that the Topanga Cession remains squarely on the Maumee Reservation, and my co-counsel will be arguing that New Dakota's transaction privilege tax is valid as applied to the development on the Topanga Cession. We would like to reserve 2 minutes at the end of our arguments for rebuttal.
Granted.
Thank you. We respectfully ask the court to reverse the decision of the 13th Circuit. This case is about a tribe's ability to exercise sovereignty within the boundaries of its own reservation and to set economic priorities within that reservation. Therefore, I will be arguing for the first issue that the Topanga Cession remains squarely on the Maumee Reservation for 3 reasons. First, that the Maumee Reservation boundaries survived the treaty with the Wendat. Second, the Maumee Reservation was not diminished by the Maumee Allotment Act and survived allotment. Lastly, I will be arguing that the Wendat Reservation was diminished by the Wendat Allotment Act. I'll turn first to the issue of the treaties in this case. The treaty with Wauseon, ratified in 1802, established the Maumee Reservation. It clearly established that the Maumee would have lands west of the Wapakoneta River, which included the Topanga Cession, the disputed parcel of land in this case. When the treaty with the Wendat established the Wendat Reservation some 6 decades later, it also included language which may indicate that the Wendat band received lands that could include the Topanga Cession, because in the 1830s, the river, which forms the boundaries of the 2 reservations, had moved. However, looking at the treaty with the Wendat, there is no statutory language that shows that it intended to diminish that Congress intended to abrogate the Maumee Reservation via this treaty.
Counselor, can I ask a question quickly, please? Did the Treaty of Wauseon, did it explicitly call out a reservation? Does it use the word reservation in the treaty?
Your Honor, I believe it does. It reserves land for the Maumee Nation. This court has repeatedly held under United States versus Dion that Congress must show explicit intent to diminish the pre-existing treaty rights of Indian nations, and that courts should use caution and impute good faith to Congress when deciding whether that intent was present. Similarly, under United States versus Payne—
Counselor, may I ask a question? In Dion, how did it resolve the abrogation question?
Your Honor, United States versus Dion is applicable in this case because that case explicitly addressed the issue of treaty abrogation, and the court there held that Congress may abrogate Indian rights under a federal treaty if there's clear evidence that Congress intended to do so. And therefore, that's why we're using this as the standard for the treaty argument in particular. Similarly, in United States versus Payne, we see that the intention to alter or abrogate a treaty should not be lightly attributed to Congress, and that extinguishment of tribal rights requires a plain and unambiguous action on the part of Congress. Here we see no text within the Treaty of the Wendat which explicitly references the Maumee Reservation. There is nothing within the treaty that says that Congress intended to abrogate the Maumee Reservation or to take away any of the rights the Maumee would have had toward the Topanga Cession. Additionally,
Counselor, can't we also look at some legislative history to find abrogation?
Yes, Your Honor. Under United States versus Dion, we can look towards legislative history and other extra-textual evidence in order to determine diminishment. However, the court is clear that Congress must pass two hurdles before this must be done. First, Congress must show within the extra-textual evidence that they clearly understood the conflict between the treaty and the action that they are wanting to take. Second, Congress must explicitly show within the extra-textual evidence of the treaty itself that it intended to abrogate the first treaty with the second one, or that it intended to solve that conflict with the second treaty. We have neither of those things in this case. The court would have to find contextual evidence that Congress understood the conflict between the Wapakoneta Rivers movement and resolved that conflict by divesting the Maumee Reservation of the Topanga Cession.
And so, Counselor, I'm sorry, how do we know if Congress did then consider the Maumee when it ratified the Treaty of Wendat?
Your Honor, we know that Congress considered the Maumee only by looking at the legislative record, because we see Senator Foote indirectly reference the existence of the Treaty of Wauseon by mentioning that the Maumee had been in the area before but seemed to have cleared out. But he didn't reference the fact that he thought the Treaty of the Wendat would affect the borders of the Maumee Reservation in any way. So the Maumee Nation was indirectly referenced through the legislative record, but not to the point where it showed that Congress met that bar under United States versus Dion and actually understood that there was a conflict between the Treaty of the Wendat and the Rivers movements. Therefore, we'd like to ask the court to look at this treaty and say first, in a more narrow reading, that clearly the Maumee Nation, the Topanga Cession still remains on the Maumee Reservation after the treaty with the Wendat. But if the court were to find that the treaty with the Wendat was ambiguous in any way and did abrogate part of the Maumee Reservation, that this was a de facto joint interest between the two reservations. And this remained to be a gray area of ownership until we look at the allotment acts, which clear up any confusion that the court may have over who owns the Topanga Cession.
Counselor, I have a quick question. Is there a treaty journal for either treaty? Do we know what what was being negotiated and interpreted, or the interpretation of the treaty negotiations from the side of the indigenous people that were negotiating the treaty? Or are you only relying upon congressional legislative history to interpret those treaties?
Your Honor, unfortunately, we don't have the records which show the negotiations with the treaties or what the tribes understood in this case. This is why we're advocating for a broad reading of these treaties, which focuses on treating both of the treaties as if the tribes fully understood what was at stake here, and doesn't unjustly abrogate the boundaries of any tribe.
So if there's any ambiguities in interpreting the treaty, how are we supposed to interpret those ambiguities?
Any ambiguities within the treaty can be interpreted by looking at the extra-textual evidence in this case, Your Honor. However, in this instance, the extra-textual evidence is also ambiguous. So so that's why we're advocating for the joint interest theory, because we believe that any further confusion can be cleared up by the allotment acts in this case. Turning first towards the Maumee Allotment Act of 1908, this did not diminish the Maumee Reservation, as evidenced both by the language and the extra-textual evidence in this act. So under McGirt versus Oklahoma, we know that when analyzing whether or not an allotment act diminished a reservation, we must first look towards the text of the act itself. And only if that is ambiguous can we turn to the extra-textual evidence. In this case—
Counselor, didn't the Maumee agree in the Allotment Act that the entire eastern quarter of the grid, the parcel that we're talking about, is surplus and it should be returned to public domain? Doesn't that indicate some diminishment?
Your Honor, while there is language that references cession in the Maumee Allotment Act, the language says that the Maumee Nation may cede those lands to the public domain. And we read this text of the act as parallel to the General Allotment Act of 1887, whereby Congress allowed the president to open all federal Indian tribes up for allotment and just created the pathways without necessarily taking those pathways. So similarly, the Maumee Allotment Act opened the Maumee Reservation to the possibility of allotment, but the pathway to return lands to the public domain was not taken. And we can see that this is evidenced in the language in the act which references payment. The act says, and I quote here, "The United States shall act as a trustee for said Indians to dispose of the said lands and to expend and pay over the proceeds from the sale thereof." Therefore, we see the United States was not giving the Maumee Nation some certain payment to compensate them for land so that it may be returned to the public domain. Instead, this is similar to Solemn versus Bartlett, where the United States was acting as a broker for the tribes and for the tribe, excuse me, and would only remit funds to the tribe for the lands actually sold. However, because the language of this Allotment Act is ambiguous, it is appropriate to look at the extra-textual evidence here, as is allowed under McGirt versus Oklahoma. And the ambiguity in statutory language is the only time that we may do so. However, this extra-textual evidence cannot override the meaning of the text in the act itself. Prior to the passage—
Counsel, how looking at the other evidence that is present here, how are we to treat the census data that is in the record?
Your Honor, the census data is extra-textual evidence that may be considered as one of the factors outlined in Solemn versus Bartlett. However, under Nebraska versus Parker, we know that the value of the demographic evidence is only interpretive and used to shed light. And even in Solemn versus Bartlett, we see that the demographic evidence should not be given great weight when combined with all the other extra-textual evidence. However, even in this case, we see that the demographic evidence is consistent with our interpretation of the Maumee Allotment Act because it shows that the Maumee Reservation was open to allotment, but the reservation's boundaries remained intact. And certainly, if non-Indian settlers were allowed to buy land on the reservation, the American Indian population would in fact dip in those areas. And so we believe that's entirely consistent with our reading of the act. Looking to the congressional record, in the summer of 1907, we see that an Indian service-connected Major Hans met with the Maumee Nation in order to discuss the potential terms of the Maumee Allotment Act. And unlike in South Dakota versus the Yankton Sioux Tribe or Decoteau versus District County Court, we don't know that these negotiations showed an understanding on the behalf of the Maumee tribe that the Maumee Allotment Act would modify the boundaries of its reservation. In fact, we see that legislators, when discussing the passage of the Maumee Allotment Act, asked to clarify that all lands unsold will continue to belong to the Indians, and until there's payment, the land belongs to the Maumee. So this seems to be the understanding on behalf of the congressman as well. Turning now to the Wendat Allotment Act, we see that although this act is similarly ambiguous to the Maumee Allotment Act, this shows clear diminishment when looking at the text of the act and the extra-textual evidence. So this, the Wendat Allotment Act—
Counselor, may I ask then, because of the use of session language and the phrase of return to the public domain, as you might be aware of, indicate that Congress then intended to diminish the Maumee Reservation after all?
Your Honor, we believe that the reading of this language, when taken with the reading of the act as a whole, shows the opposite conclusion. And under McGirt versus Oklahoma, we know that there are no, quote, magic words that signal diminishment. So the act must be read as a whole. And when we look at the ambiguous language when it comes to payment and the piecemeal payment structure combined with the extra textual evidence, it's clear that Congress did not intend to diminish the Maumee Reservation. However, as contrasted to the Wendat Allotment Act, this is a great example of a time when Congress did intend to diminish an Indian reservation. The Wendat Allotment Act outlines Congress's promise to pay the Wendat a lump sum of $2.2 million. And although there's ambiguous session language within the act, we see that following the passage of the act, no member of the Wendat band selected a parcel on the Topanga cession. And we know that Congress paid the Wendat band $2.2 million. So there's no other conclusion but to show that Congress intended to diminish the Wendat reservation and that it was diminished. Therefore, we respectfully ask the court to reverse the decision of the 13th Circuit and find the Topanga cession on the Maumee Reservation. Thank you.
Thank you. Counsel, you may begin.
Good evening, Your Honors, and may it please the court. My name is Eric Ralston, and I will be arguing on behalf of the petitioner Maumee Nation that the doctrines of infringement and preemption do not apply in this case, and the court should reverse the decision of the 13th Circuit. These doctrines are important protections against state interference into tribal affairs, but they do not apply here when the tribe on whose reservation the activity occurs, that of the Maumee Nation, seeks enforcement of the tax, and when the state has taken steps to ensure that tribal interests are being protected. My argument consists of 3 points, the first 2 relating to Indian preemption, and the third relating to the doctrine of infringement. First, I'll review why there is not a categorical bar to this tax under the doctrine of Indian preemption. Second, I will review why under White Mountain Apache Tribe versus Bracker, the federal, state, and tribal interests point in favor of allowing the tax. And lastly, I will review the doctrine of infringement and why this does also not bar the tax. Now, before beginning my argument, I want to make clear on what is the question presented to this court and the Maumee's interests. The court is asked to assume that this is located within Indian country. A New Dakota's tax statute calls for funds that are collected within a tribe's reservation to be remitted to the tribe itself. Thus, the Maumee's interests are in the activity occurring within its own reservation. And I will be arguing with the assumption that the court finds the development is located within the Maumee Nation reservation, and we are not arguing that a state may tax a development located within a tribe's own reservation. First,
Counselor, why is that? Why can't states generally tax an Indian country?
Your Honor, when considering whether a state can tax within Indian country, the relevant inquiry is into who bears the tax and where the taxation occurs. So for instance, when a tribe is operating within its own reservation, this court articulated in Oklahoma Tax Commission versus Chickasaw Nation that the state is categorically barred from applying this tax. However, when a tribe is operating outside of its reservation, Chickasaw Nation noted that the tribe is generally subject to state taxation. This is consistent with this court's geographic approach to tribal sovereignty, which performs a necessary backdrop to the Indian preemption analysis. So in Mescalero Apache Tribe versus Bracker or versus Jones, for instance, you had a tribal corporation that was operating outside of its reservation boundaries. And this court held that when leaving reservation boundaries, the tribe is generally subject to a non-discriminatory state tax. Here, we have a tribe, that of the Wendat Band, operating outside of its reservation boundaries. Thus, this categorical approach to preemption does not apply here. This would be especially inappropriate in this case when we have the tribe on whose reservation the activity occurs seeking enforcement of the tax, given it would allow a tribe to operate outside of its reservation boundaries on a separate tribe's reservation boundaries and claim which laws apply to that tribe, even when it goes against the express wishes of the tribe on whose reservation the activity occurs. Thus, because the categorical bar does not apply, we can turn to Indian preemption analysis under White Mountain Apache Tribe versus Bracker. When considering—
Counselor, whose sovereign interests are the strongest in this situation?
Your Honor, in Bracker, the court noted that there's a significant geographic approach to tribal sovereignty, and thus, because this is Maumee Nation land, their interests should outweigh those of the Wendat Band. So the Maumee Nation's interests should be considered more prominent in this case. So Counselor, between the two tribes, I mean, would you agree that they're on equal footing with each other? No, Your Honor. Because this is Maumee Nation land, we think that the interests the court should consider in its preemption analysis is those of the tribe on whose reservation the activity occurs, and that is of the Maumee. So
but isn't this a state tax though, Counselor?
Yes, Your Honor, but under this Bracker analysis test, the court has consistently considered the interests of the tribe on whose reservation the activity occurs when considering in its weighing of the state, federal, and tribal interests at stake.
So Counselor, when thinking about the two tribes in the state, are the two tribes in the state on equal footing?
Your Honor, this case is, Your Honor, no, because we have this tribal sovereignty interest of the reservation, the Maumee Nation's interest in this case should supersede that of both the other tribe as well as the state. But because this case is unique, given that we have the tribe seeking enforcement of this tax, this strongly weighs in favor of allowing the state to apply this tax within Maumee Nation reservation boundaries. So thus, in considering the federal, state, and tribal interests, we can consider these interests in turn, starting with the federal interests. So the federal interest that this court has looked at is whether there are extensive, exclusive federal programs that relate to the tax activity. In Bracker, the court barred a tax because that was supposed to relate to timber activity occurring within a reservation, because the federal government's regulations regarding timber activity left no room for state regulation. In addition, in that case, the tax was applied to the use of roads within the reservation that were owned, maintained, and operated exclusively by the federal government. In contrast, in Cotton Petroleum Corporation versus New Mexico, this court allowed a state tax within a reservation because it noted that the state was providing funds that benefited the tax entity, indicating that the state had a regulatory interest in the tax case there. This case is much more like Cotton Petroleum Corporation, given that there are not these extensive exclusive federal interests that relate to the tax activity, which is gross sales proceeds of a commercial development. The state itself, in its tax statute, note that it's providing specific services to benefit commercial activity within the state, including through funding for infrastructure projects and funding for the Department of Commerce. Thus, this case is much more like Cotton Petroleum, indicating that when considering the federal interest, they point in favor of allowing the tax here. Now, 2 other points on federal interest. Although the development may include housing and nursing facilities, these entities are not being taxed. The tax is applying to the gross sales proceeds of a construction company, of a commercial development. This court has consistently looked at the actual activity that is being taxed. In addition, because we have the tribe on whose reservation seeking enforcement of the tax, if the court were to find that the federal interests bar the tax, it would effectively be saying that these implied indirect federal interests outweigh the interests as expressed by the Maumee Nation. And respectfully, the Maumee Nation should be able to decide which laws apply within its reservation and which interests should be protected. So thus, when considering the
Well,
federal—
Counselor, then if legal instance does fall on, if legal instance of tax falls on non-Indian purchasers, if the case were to be, could tribal corporations be required to then assist the state of New Dakota by collecting and or remitting the tax? And how would that look?
Yes, Your Honor. If the tribe fell on non-Indian purchasers in Washington versus Confederated Tribes of Colville Indian Reservation, this court held that when a state tax is valid, the state can impose a minimum burden on the corporation that would be collecting the tax and remitting the funds to the state. So we think that would apply in this case. So when considering the tribal interests after the federal interests, again, this court, because of its geographic approach to tribal sovereignty, should consider those of the Maumee Nation. And because they are seeking enforcement, this case is unique and should indicate that tribal interests point in favor of allowing the tax in this case. This case is also unique given the steps that the state has taken to ensure that tribal interests are being protected. In Crow Tribe of Indians versus Montana, the Ninth Circuit noted that a state should narrowly tailor its tax statute to ensure it promotes its interests while still taking into account federal and tribal interests. And the court affirmed that decision, and the state is doing this in 3 ways. First, for tribal activities that are occurring on a tribe's reservation on land held in trust, those activities are not subject to the tax. Second, for other activities occurring on a tribe's reservation, the proceeds of the tax are being remitted to the tribe. And third, in consideration of mineral interests that the Maumee Nation gave up in Door Prairie County, a portion of the proceeds collected in that county outside of Indian country are being remitted to the Maumee Nation. Given that the steps of this—
Counselor, you have noted here how it does align between the Maumee Nation and federal goals, but how doesn't it?
Your Honor, can you repeat your question?
What issues might we see because of disalignment? You spoke of 3 points that where the tribe, how the alignment with the feds work in this case. How don't they align? How might they not?
So in considering, Your Honor, when I was discussing those interests, those weren't considering the state's interest and the state's consideration in drafting its tax statute for the tribe. So the tribal interest and the state's interests are interrelated in this case, given that the state has taken steps to ensure that tribal interests are being protected and they are remitting the funds to the tribe itself. This court has noted a number of guidelines for how it has considered state interests under this analysis. For instance, the state should have more than a generalized interest in raising revenue. The state should narrowly tailor its tax statute to ensure it promotes its interests while also accounting for tribal interests. And when the state has a regulatory interest in the tax activity, this points in favor of allowing the tax. The state is meeting each of these burdens that this court has laid out, given that it has specific purposes for the tax in promoting commercial development activity, including through for specific projects. That activity is benefiting the tax entity, and the funds are being remitted to the tribe, indicating that the economic burden does not fall on the tribe itself, which is another requirement that has been held, or which was another way that this case is different from Bracker, where the state tax was barred, and other cases that have considered and used that same analysis. So in considering—
So counselor, how did the 13th Circuit get it wrong? can you explain to me, like, you know, how they got it wrong and why we're sitting here today?
So, Your Honor, the 13th Circuit ruled in favor of the respondent on both issues. So they ruled in favor of the respondent on both issues. First, on the issue relating to the land being within the Wendat Reservation. And as noted in the beginning, we agree that if the court were to find that the land is located within the Wendat Reservation, this would strongly favor the state not being able to collect the tax in that case. However, because we argue that the court should find that the land is located within the Maumee Nation Reservation, the doctrines of infringement and preemption, given this court's geographic approach to tribal sovereignty, should lead the court to find that the tax would be allowed in this instance. Given that this case is fairly unique,
Counselor, aren't the tribal interests the same? Regardless of which tribe actually ends up getting the land, it is in essence tribal land. So it seems to me that there's an equality issue there, equal treatment for the tribal land.
Your Honor, we agree that there is equal tribal interest in the Wendat Band trying to prevent the state from applying this tax and the Maumee Nation in trying to get the state to apply this tax. However, when considering these interests, we think that tribal interests more generally should take into account that when activity is occurring on a tribe's reservation and that tribe is seeking enforcement of a state law, this should be a stronger interest, or the court should find this to be a stronger interest compared to the interest of the other tribe in seeking avoidance of the tax.
And
Given that when a tribe operates and leaves its reservation boundaries, its sovereignty is significantly lower compared to when it is operating within its own reservation. And this can be seen most clearly that if we look to Mescalero Apache tribe versus Jones, the court noted that when a tribe leaves its reservation boundaries, it's generally subject to a state taxation. However, in Chickasaw Nation, the court noted that when a tribe's operating in its own reservation, it is generally not subject to state taxation.
And
So
how do we-
Counselor,
go forward, please.
please, Chief Justice.
How do we make use of then the census data related to the populations in the Session parcel?
So, Your Honor, in Oklahoma Tax Commission versus Sac and Fox Nation, the court noted that its conception of Indian country was relatively broad. So even if the census data indicates that a significant amount of reservation Indians had left the area and the percentage of those who were living in the area had diminished, when considering whether a state tax would apply within a tribe's reservation, this can apply whether the land is owned or operated by the Indians themselves, or whether it is on fee land or an informal reservation. So we think that when considering the preemption analysis, the relevant inquiry is where the reservation boundaries are, and if the tribe is operating inside or outside of reservation boundaries, no matter the demographics in this case. So lastly, just in considering the doctrine of infringement, this is also not a bar to this tax, given that in Williams versus Lee, this court noted that state authority is barred when it interferes with the right of reservation Indians to make their own laws and to be ruled by them. Again, this case is unique because we have two separate tribes that are arguing over the same tax. However, because of the strong geographic component to tribal sovereignty, and we have the tribe on whose reservation the activity occurs seeking enforcement of the tax, the other side cannot argue that the doctrine of infringement applies here, given that in preventing this law from being applied against the express wishes of the Maumee Reservation, that itself would interfere with their ability to make their own laws and to be ruled by them. That's the doctrine.
Counselor, but wouldn't their argument be stronger if they were trying to enforce their own tribal tax law instead of a state tax law?
Your Honor, I agree that the analysis may be different and may in fact be stronger. However, when considering whether the state has authority, it's still considering this as the test of whether the tribe is trying to be ruled by its own laws. And when it's expressing an interest in these laws, this does not change its analysis, or it's not related to a bar. The state
Counselor, at the end of the day, is the land Indian country?
Yes, Your Honor. And given that we have the tribe seeking enforcement of its own tax, this should indicate that the tax should be allowed in this case. And the court should reverse the decision of the 13th Circuit, finding first that the land is located within the Maumee Nation Reservation, and second, that the tax is allowed in this case under the doctrines of Indian preemption and infringement. Thank you.
Thank you. We will hear from Ms. Depew.
Bailiff, are you ready?
I'm ready.
Thank you. Chief Justice, Justices, and may it please the court. My name is Emily Depew, and along with my co-counsel, Zach Kelsey, we represent the respondent, the Wendat Band of Huron Indians. This case is about the text of 2 treaties and 2 allotment acts. The question in today's case asks, is the Topanga cession within the Wendat Reservation? The answer to that question is yes, for 2 reasons. First, the Topanga cession has been in the Wendat Reservation since the treaty with the Wendat in 1859. Second, the Topanga cession continued to be within the Wendat Reservation even after the allotment era. Therefore, we request that you affirm the decision of the 13th Circuit Court of Appeals and honor the text of the Wendat Treaty.
Counselor, as I understand it, when the treaty was signed, both treaties, years apart, the boundaries of the river had changed. What do we do with that fact?
Yes, Your Honor. I have 2 responses to that. First and foremost, we know that Congress knew the river had changed during the 1830s. You can look to the physical evidence within the treaty with the Wendat, specifically Section 6 of the treaty with the Wendat, which states that Congress sent Indian agents on behalf of Congress to the banks of the Wapakoneta River to sign the treaty. Congress was there. They were on the banks when this second treaty was signed. They knew that the river had moved. Furthermore, if you turn to the legislative history, page 29 of the record, opposing counsel pointed to Senator Foote's statement. Specifically, there are 3 things that you need to discern from Senator Foote's statement. First, he mentions the Maumee. Second, he mentions the Wapakoneta River. And third, he even mentions the Treaty of Wauseon. It was not just a reference. Congress knew that the river had changed, and there's both evidence in the treaty with the Wendat and in the respective legislative history.
Counselor, does the treaty on its face, does the language of the treaty abrogate the prior one?
Yes, Your Honor.
Or are you solely relying upon legislative history to make that interpretation?
I have 2 responses to that, Justice Adams. First and foremost, on the face of the treaty with the Wendat Act, the Treaty of Wauseon was abrogated. Today, this court has the opportunity to read these 2 treaties harmoniously. The Maumee should receive all lands west of the river, and the Wendat should receive all lands east of the river. In United States versus Dion, this court found that it was not necessary to mention the tribe's name when abrogating their treaty. Specifically in that case, the Yankton Sioux tribe was not mentioned when their treaty rights were abrogated under the Endangered Species Act. It is not a necessary requirement by any stretch of the imagination. But secondly, even if you believe that the text is to be ambiguous, turn to the legislative history, which shows on page 29 of the record that Congress knew that the river had changed. Furthermore,
Counselor, is there a treaty journal? Do we know what the Indians at the time thought about when they were negotiating the treaty, or are we, again, just kind of relying upon the record of the colonizer?
Justice Adams, unfortunately, you are absolutely correct. We're dealing with a limited record in this case, and the record does not show any treaty journals which would indicate the Indians' intentions. So
Counselor, were there any historical experts that were hired by either of the parties? Was there any type of like ethno-historical study done that was part of the record before the lower courts?
Your Honor, to our knowledge, that was not available, and nor is it available in this very limited record. So unfortunately, we do just have to look to the legislative history of Congress to discern any ambiguities there potentially could be in the text. But an additional
Counselor,
reason,
how does
Counselor,
I'm sorry, go ahead.
go ahead. Well, Counselor, I was going to ask about Dion, and if I recall correctly, our precedent in Dion requires a showing that the Congress at least was aware of the conflict. What clear evidence of that conflict awareness is there in the record?
yes, Your Honor, I have two responses to that. First, Article 6 of the treaty with the Wendat, which shows that Congress was physically on the banks of the river when the treaty with the Wendat was signed. And secondly, page 29 of the record, which shows that Congress knew of the Treaty of Wauseon in connection to the treaty with the Wendat. But furthermore, Your Honors, if you turn to Article 3 and Article 4 of the Treaty of Wauseon, you will see that Congress promised the Maumee 4 major waterways. In the treaty with the Wendat, Congress only promised the Wendat 1 major waterway. And today, if this court was to find that the Wendat, the treaty with the Wendat did not abrogate the Treaty of Wauseon, that would mean that the Wendat would not have access to the Wapakoneta River. This was a very important interpretation tool to show evidence that Congress may potentially have wanted to abrogate the Maumee's treaty. Furthermore, when these treaties were signed, it was approximately the mid-19th century. This river was a massive landmark in between these two tribes. It was a way to delineate between one tribe's boundaries and the other tribe's boundaries. It is logical for this court to conclude that Congress wanted to abrogate the Treaty of Wauseon, both to give the Maumee access to the Wapakoneta River, but additionally to delineate between these two tribes in a very in the landmark of the Wapakoneta River. Lone Wolf versus Hitchcock stated, this court stated in Lone Wolf versus Hitchcock, that it would be logical for Congress to abrogate a treaty when it is in the interest of Congress and the Indian tribe. In this case, it's in the interest of Congress to know the tribal boundaries between these two, between the Maumee and the Wendat, but it's additionally in the interest of the Indians to allow the Wendat access to the Wapakoneta River.
So, Counselor, does the abrogation, does it have to be clear? Does it, or can it be insinuated? Can it be referred to in reference, or does it have to be explicitly clear when Congress intends to do that?
Your Honor, under Dion, it does not have to be explicit. There has to be clear evidence that Congress intended to abrogate a treaty, but specifically in Dion, in the Endangered Species Act, this court abrogated the Yankton Sioux tribe's treaty rights without even mentioning the Yankton Sioux tribe.
So, Counselor, but how does that harmonize with what the justices said in McGirt? I thought in McGirt that things had to be crystal clear, that treaties meant something, that they, like the express words of a treaty and Congress's actions explicitly meant something.
Justice Adams, you're exactly right. But in today's case, we're dealing with treaty abrogation and diminishment through allotment acts. This court's controlling test for treaty abrogation is United States versus Dion. However, this court's controlling test for allotment acts is McGirt versus Oklahoma, which directly brings me into my second point, which is that the Wendat Allotment Act did not diminish the Wendat territory. Under McGirt versus Oklahoma, this court stated that, quote, the most probative evidence of congressional intent is to look to the statutory text. Opposing counsel directed your attention to the legislative history. However, when Oklahoma attempted to do this both in brief and in oral arguments, the majority stated, quote, this is mistaken, because the first place and the only place to look at when interpreting an allotment act is the explicit text. And when you turn to the explicit text of the Wendat Allotment Act, simply put, there is no cession language. In Matz versus Arnett, this court noted that
Counsel, on that point, let me ask you about the some certain. Isn't there a reference to a some certain payment received by the Wendat?
Precisely, Chief Justice. However, that is not an issue in this case. The most recent Allotment Act case this court interpreted was Nebraska versus Parker prior to McGirt. And in Parker, this court unanimously held that when an Allotment Act does, quote, merely open the reservation land to settlement and provide an uncertain future proceed of settler purchases to be applied to the Indians' benefit, that does not equal diminishment. And if you look to the Wendat Allotment Act, that language mirrors Parker almost precisely.
So counselor, don't we have two allotment acts here? Like, so what's your point in terms of how do we distinguish in terms of your argument? How do we distinguish between the two allotment acts?
Yes, Your Honor. First and foremost, we are not here to argue that another tribe has been diminished. We have no intention on infringing on their sovereignty. Today, we are here to just argue about the Wendat Allotment Act and to show you that the Wendat was not diminished.
But counselor, I mean, I apologize to interrupt you mid-thought, but I mean, so you're essentially saying we can read the allotment acts in a vacuum, that they're totally independent and siloed off from each other, despite the fact that they both impact the same piece of land?
Not necessarily, Your Honor. Under the petitioner's view, they believe that it's important to look at the Wendat Allotment Act because their alternative argument is to find the Topanga cession in non-Indian country. Alternatively, they want this land to be within state control. However, the Wendat do not. We want the Topanga cession to be found to be in Indian country. And we believe that the Wendat Allotment Act shows that the Wendat was not diminished and still have that claim to the Topanga cession. Furthermore, even if you believe that the Wendat Allotment Act is ambiguous, you can turn to the legislative history, specifically pages 19 through 21 of the record. Multiple representatives state that the purpose of the Wendat Allotment Act is to, quote, open the land to non-Indian settlers. And in Seymour versus Washington Superintendent, this court stated that many times allotment acts did, quote, no more than open the reservation to non-Indian settlers to own land, meaning that Congress did not have an intention to diminish the tribe. All they wanted was for non-Indians to come onto the land and to use the land. And that's what we have in this case. When you turn to the legislative—
So counselor, why shouldn't Hagan and Yankton control here?
Yes, Your Honor. McGirt is the most recent case that this court has interpreted under the Allotment Acts. And furthermore, in South Dakota versus Yankton Sioux and in Hagan versus Utah, this court did find diminishment based off of cession language. For instance, in Hagan versus Utah, this court found that diminishment had occurred because of two reasons. First, there was the words public domain. And secondly, there was a some certain language. And in Dakota versus District Court, this court noted that when those cession language and some certain are paired together, there's an almost insurmountable presumption that Congress meant to diminish the tribe. However,
so there are counselor, there are some magic words then.
Your Honor, under McGirt specifically, there is no, quote, magic words, but magic words can be, or cession language can be helpful in determining congressional intent. Like in Matz versus Arnett, this court noted that language such as abolished, terminated, or vacated can be indicative of Congress's intent to diminish.
But counselor, isn't the payment of some certain clear evidence then that Congress intended to diminish the Wendat reservation?
No, Your Honor, under the presumption that it is to be held in the Treasury on behalf of the Indians' benefit. That is what was found in Parker, and that's also what is found in the Wendat Allotment Act. There is no some certain language sufficient to show that Congress wanted to diminish the Wendat reservation. It's just simply not there. Congress promised all lands west of the river to the Maumee and all lands east of the river to the Wendat. Congress hasn't taken back either of those promises. And this court today should enforce and keep Congress's promises. Therefore, we ask that you affirm the decision of the 13th Circuit Court of Appeals and find the Topanga Session within the Wendat Reservation. Thank you.
All right, counsel, you may begin.
Chief Justice, Justices, and may it please the court. My name is Zach Kelsey, and I'm here on behalf of the respondent, the Wendat Band of Huron Indians. My co-counsel, Emily Depew, just told you about the text of 2 treaties and 2 allotment acts. Now I'm going to talk to you about the text of New Dakota's taxing statute to resolve a narrow question. Can New Dakota tax the Wendat Development Corporation when operating in Indian country? We say they cannot for 2 reasons. First, New Dakota's tax is preempted because when tribal and federal interests are extensive, the door is shut to the state. Second, New Dakota's tax infringes on tribal sovereignty because it locks the tribal council out of important economic decisions on the reservation. For these 2 reasons, this court should affirm the decision of the 13th Circuit Court of Appeals. First, when looking at the issue of Indian preemption, opposing counsel pointed us to 2 cases to support the idea of a geographical approach to Indian preemption. However, the geographical approach does not apply between 2 tribes occupying Indian country. Rather, the distinction should be made between state land and Indian country alone. Both of the cases
And so, Counselor, when you speak of distinction, and perhaps I'm jumping a bit ahead on your argument here, but when we talk about tribal governments, are they not different and separate and distinct entities from tribal corporations, which we're speaking on here?
That's absolutely right, Your Honor. Tribes are not a monolith. Each tribe is entitled to its own sovereignty within Indian country. Now, the Wendat Development Corporation is a Section 17 entity, which means that it retains the same sovereign immunity and tax immunity that the tribe itself does. Now, opposing counsel would have you believe that when the Development Corporation is operating on the Maumee land, on Indian fee lands that it purchased, that it suddenly becomes a non-Indian entity. That is inconsistent with federal law and this court's precedent. If you look to the previous counsel's previous cases, they cited Mescalero Apache v. Jones. In Mescalero Apache, the Mescalero were operating a ski resort on state land. In that case, the state's interest to regulate through taxation was acceptable. But here, we're not on state land. The Wendat Development Corporation is operating in Indian country. When that's the case, the door is shut to the state. Second, opposing counsel.
I'm sorry, Counselor, could you point me to how it is separate when we are speaking of a Section 17 situation where the state might be involved in licensure or feds as well?
Yes, Your Honor. So specifically with Section 17, entities are assigned a federal charter. Now, this is different than when tribes organize under a state charter. When they're organizing that way on state land, we completely concede that they are subject to state taxation. But when they apply to the Secretary of the Interior for a Section 17 license, as long as they're in Indian country, the state may not walk through the door that Congress left shut. Now, looking at the way that Section 17 applies here, we can look to opposing counsel what they cited with the Colville case. In Colville, it's quite different than the case that we have here. Specifically, Washington was attempting to prevent the shipment of unstamped or untaxed cigarettes onto the Colville Indian Reservation. In that case, this court found that while the state could stop non-Indians from trafficking these untaxed cigarettes to the reservation on state land, it lacked that same authority in Indian country. Furthermore,
Counsel, isn't this closer to the Blaze construction case?
No, Your Honor, it absolutely is not. Because the difference here is that we have a tribe operating in Indian country. That's the bright line scenario that this court has previously held. And admittedly, this is the first instance which a tribe has been operating on another tribe's reservation, but a tribe should not lose its Indian status just because its Indian fee land is located within a larger reservation by the state. Now, opposing counsel asserts this geographical approach to preemption, But the geographical approach and the boundary lines that they propose ignore the fact that the Wendat bought this land in fee as Indian fee land. Unlike previous decisions such as Atkinson Trading Company v. Shirley, where it was a non-member, non-Indian operating on a fee plot, that same protection does not apply to non-Indians. But because we have an Indian here, the protection applies. Their sovereignty is invoked in this instance.
But counsel, when you speak about that, the state does have to play an important role, as far as we understand it, in building roads and being able to maintain infrastructure when we speak about fee lands. And so how is that? It seems in contradiction to what you're speaking about, where it almost seems that they don't play a role. Could you explain that? And also, how can development still go on if there is a state role?
Yes, Justice Thunder. So respectfully, we do acknowledge that in some fee plots, some states do play a role, but here they don't. The state of New Dakota doesn't provide for road infrastructure on this fee plot in the reservation. They don't do that. Opposing counsel pointed you to Cotton Petroleum, and they say that when the state provides benefits to the taxed entity, that's an acceptable state interest. But that's not what's happening here. The state of New Dakota isn't helping the tribes in any way. It's remitting the proceeds from one tribe and giving it to another. That is not the way that the Congress intended for the state to interact with Section 17 entities. Now,
Counselor, would the analysis change depending on if like say it were just a totally different type of business that was being conducted?
Yes, Your Honor. So there are two distinctions that are made in the area of taxation. There's the supply side taxation in cases like Arizona Central Machinery, where it's taxing on tractor shipments to the reservation. In those cases, in some instances, the burden is different because it's traffic from state land onto the reservation. There are also transaction-based statutes, like what opposing counsel cited with Movi Confederate Tribes of the Salish and Kootenai Reservation. In those cases, there must only be a minimal burden on the tribe. And that actually moves me to my second point here today. This is far more than a minimal burden because it's infringing on the sovereignty of both tribes. Now, the Maumee assert that they want the state to assert and enforce this tax on the reservation because they have no other alternative. But that's not what's happening here today. At the moment, the Maumee are in favor of this statute because it's providing them revenue that they wouldn't have otherwise. But that's not.
Counselor, because this is very unique, this is this kind of question has not been before the court, where you have, as you say, Indian country, but you have two tribes who have different interests. How is this court to weigh those tribal interests and to consider both those tribal interests?
Yes, Your Honor. So I have two responses to this. First, the Wendat's interest should be weighed more heavily because they're the entity bearing the burden of the tax. Second, even if the Maumee do have a sovereign interest in taxing, that can only be achieved through a tribal state compact. The Maumee say that right now they consent, but what if that changes? Right now, the decision to raise or lower the 3% gross proceeds tax is not made on the reservation. It's made in the state capital. What many states, such as the state of Oklahoma, is doing now with the Muskogee Creek Nation after the recent decision of McGirt is they're negotiating the enforcement of state sales taxes with the consent of the sovereign. Similarly, in Montana, that state is engaged in tribal state compacts with all 7 tribes operating in their reservation for the collection of taxes related to cigarettes and alcohol. That is the distinction that should be made. The state's interest is minimal when you're weighing the interest between 2 tribes. Instead, the state should be required to knock on the door before entering the reservation for taxing authority. Nowhere in the record do we see any indication that New Dakota statute is negotiated with the sovereign authority of the tribes in mind. The tribes need to be able to say no, and they need to be able to require the state to knock first. Furthermore, when looking at the previous decisions for the transaction side taxes, such as Movi Confederate Tribes of the Salish and Kootenai Reservation, that was a minimal burden because it was only on one tax. It was only on one good, cigarettes, which are taxed almost everywhere. It wasn't a major burden on the tribe to just keep records of transactions with members and non-members. But here we have 2 differences. New Dakota's tax is not narrowly tailored. It makes no distinction between transactions between Wendat members and state members. It makes no distinction.
And so,
Second.
Counselor, how might we look at this as members off reservation? Because certainly they could be benefited within state jurisdiction. It almost sounds like the argument is to completely take that away from citizens who might not be living directly on the reservation.
I completely agree, Your Honor. So if the Wendat Development Corporation was benefiting from the state's regulatory authority and it was benefiting from its roads and its police forces, then we would fully consent to this tax. But that's not the case here. Instead, New Dakota is imposing a tax on every single good sold on the reservation. The Wendat are building a grocery store to reduce the issue of a food desert on the reservation. Every single loaf of bread sold at that grocery store would be taxed by the state. They're also constructing a pharmacy. Every single pill sold at this pharmacy would be taxed by the state. That is unacceptable in light of the sovereignty of both tribes. If either tribe wanted to reduce this tax, Your Honor.
Well, but Counselor, I mean, doesn't the state have an interest in taxing those products if the state's infrastructure is used for those products to ultimately reach the reservation?
Your Honor, the state has a regulatory interest on the roads leading to the reservation. That's what happened in Washington v. Indians of the Colville Reservation. This court found that it could stop freight trucks carrying unstamped cigarettes to the reservation. But that jurisdiction stopped at the door of the reservation and it stopped at the membership status of the tribe. It didn't have that same authority over tribal members. So the distinction is bright line.
But Counselor, I'm not trying to say that the point that I'm trying to make is that if it would be different from my standpoint if the loaves of bread and the prescription medications were actually fabricated. The raw materials were created on the reservation, then they were packaged and bundled up and sold, right? Then I mean, then we've got a situation where the entire value of the goods is created on the reservation. But when you've got a situation where all of the goods are being imported onto the reservation from off of the reservation, how does that impact the tax analysis if it's not being created on the reservation?
Justice Adams, I completely agree. There's a valid state interest in the importation of these products to the reservation, but I have two responses. First, there are many products that are being sold at this Wendat Development Corporation that are produced on the reservation. The tax makes no distinction between those. Second, this is not a situation in which the tax is affecting the shipment of these goods. Like many states have motor carrier fuel taxes, like Montana did in Movi Confederated Tribes of the Salish and Kootenai Reservation. The tax here is not related to the shipment to the reservation. It's related to the transactions that occur on the reservation. The state cannot walk through that door because those transactions are behind a closed door. The state needs to knock first.
So Counselor, if I owned a convenience store on the reservation and I was a tribal member and I was licensed either under tribal law or I had a Section 17, are you trying to say that like every bag of Doritos that I sell at that convenience store is exempt from state taxation?
It would depend, Your Honor. So yes, under my interpretation, that's absolutely correct. And the court's interpretation is also consistent with that. If you look to Movi Confederated Tribes of the Salish and Kootenai Reservation, in that case, when the only burden is collection of records to distinguish between members and non-members, then that's acceptable because the state cannot enforce a tax between your business selling Doritos to a member of your tribe. That can't be done. But New Dakota's tax washes all of that away. It taxes members and non-members alike. That's unacceptable in light of this court's case law.
But Counselor, isn't the big distinction though that in this situation the tax revenues are being returned to the tribes? I mean, isn't that essentially like a de facto tax compact with the tribes?
No, Your Honor. So that returns to the very essence of how the tax is assigned. If you look to states that have these tax compacts, for example, in 2019, the Indians of the Colville Reservation negotiated one of these tax compacts with the state of Washington for the enforcement of marijuana sales on the reservation. There was negotiation between the tribe and the state about the amount of the tax, the extent of the state regulation. But if you look at the record, specifically at page 7, there's nothing about that ever occurring. These decisions about the rate of the tax, who's taxed, who isn't, these decisions are not made on the reservation. They're not made by the tribal council. The tribal council is locked out under the petitioner's interpretation. Rather, these decisions need to be made on the reservation because the state needs to knock first. So we have a twofold issue here. Either if you don't agree with me about the issue of preemption and you agree with me about infringement, that's enough. And vice versa. We only need to show you one to succeed. And we've shown you both. We've met our burden. And for these reasons, you should affirm the decision of the 13th Circuit Court of Appeals and find that New Dakota is both preempted and it infringes on their sovereignty because Congress and the tribes have shut the door to the state. The door is shut, but it is open to the tribes. For these reasons, affirm. Thank you.
Thank you, Counselor. The petitioners have sought 2 minutes for rebuttal. Who is arguing on rebuttal?
Your Honor, I will be arguing rebuttal.
All right. You may proceed.
Thank you, Your Honor. I have 2 points, the first relating to the treaty issue and the second relating to the tax issue. First, opposing counsel says that this is not about diminishing the land of the Maumee Reservation. However, opposing counsel is advocating for a treaty to abrogate the lands of the Maumee Reservation without any reference in the treaty itself to the Maumee or to the Maumee Reservation. Opposing counsel agrees that Congress's intent to abrogate the treaty must be clear, plain, and express, but demonstrates insufficient evidence that this is the case here. The court should examine the treaty using a similar analysis in McGirt, requiring explicit congressional intent rather than a simplistic analysis that relies heavily on the second treaty coming after the first treaty. Second, in considering the tax question, we agree.
Let me go back to that first matter. I thought her statement was akin to the fact that the signing of the treaty took place on the banks of the river. They clearly understood what was at stake here, and so there was an identifiable conflict. And so how does that I guess, influence your argument, or does it, or should it influence us?
Your Honor, in McGirt, the court noted the importance of explicit intent. Having somebody standing on the bank of a river and signing over a treaty does not demonstrate and meet that high requirement. Otherwise, this would create a significantly diminished barrier for when treaty lands can be diminished. Next, to considering the tax issue, we agree that this is a narrow question that this court can decide and that this is a unique case, given that we have tribes seeking enforcement of a tax. The court cannot find that a tribe can operate on a separate tribe reservation and claim that its laws supersede that of the governing tribe. There's nothing in this court's case law requiring a compact. And when a tribe is seeking enforcement of a tax in its interests, these interests point in favor of allowing the state tax. Thank you.
Thank you. We appreciate the arguments of both petitioner and respondent. We have the fully briefed matter before us, and we will take this matter under advisement. Thank you. We are adjourned.
Justices, Ashley has sent you a new Zoom link for 10-minute deliberation. Click that link, go there for 10 minutes, and after the 10 minutes, click the link that you got to this webinar to come back, and then to give feedback to the competitors. Now that all the justices are back, you can give feedback, you can talk to the competitors.
I'm going to exercise the prerogative to go first. I want to say congratulations to both teams for making it this far during the challenging time of having to argue in this Zoom setting. I myself have struggled with it over the past few months, so congratulations to all of you. This was a very interesting problem, and it was a unique problem because I think, at least from my recent recollection, there had not been a problem that sort of pitted two tribal governments sort of against each other and aligned one tribe with state interests and so on. And I thought it was a really interesting problem just in the wake of the McGirt decision. So I want to say to team 1004, you did a very nice job. And I wondered, had you won the coin toss, would you have still been the petitioner? Would you have been the respondent? But in any event, I think both counsel there had the issues clearly identified in the problem. And I think you set forth a pretty good roadmap of where you wanted to go, and then you just sort of jumped in there. One word of advice that I would give if you tend toward litigation or if you end up in appellate practice, I think a lot of judges still today are used to formal presentations. So when you come to the podium or you stand at the table, you know, my name is, you know, Paulina. I represent, you know, Maumee Nation. May it please the court, and then just start arguing. This case is about, and we ask you to find for these reasons, and then launch in. I want to say that my sense is that you've sort of lived with the issues. You had a pretty good mastery of some of the cases, but at some point I wanted to say, Paulina, you tended to shy away from a couple of the cases that were in some of the questions, but you did a really good job at going back to the argument. I think we were a pretty hot bench, and so you were as responsive as you could be while trying to maintain your poise and time. Eric, I think you did a really nice job in terms of jumping out of the gate, identifying the issues about preemption, and you were fairly responsive to the questions. So kudos to you for that. Team 1027, I want to say that I felt like you really prized their holdings. I was very Ms. Depew, how quickly you could. It was in my mastery of one case or two cases, but you seem to have studied the record as well. You threw out the record citations, go to this section of the treaty, it says that. That was very, very well done. Zachary, I think you have and I should say, Emily, you have a very forceful presence. It's not overbearing, but it's basically, I'm here to do my job, and this is what my clients pay me for. So you really had that passion. Zachary, I would say as well, you had a good mastery of the issues regarding taxation. And I think you had a little bit more of a relaxed style. You seemed very comfortable with the cases and your argument. And so I just think it was a good job. I don't have anything else substantive to add. We'll move down the line. Judge Adams, did you want to go next?
Yeah, I can go next. I'll just keep it brief. I mean, congratulations to both of the teams
Can you hear me?
Oh, yeah, congratulations to, you know, both teams for making it this far. I mean, I know I competed in the same competition in law school. I mean, it feels like forever ago. It was probably like 17, 18 years ago. Made it to the second day of each competition, but, you know, didn't make it to the finals. But congratulate you guys. I know it's a lot of hard work. I mean, and just to echo what the Chief Justice said, and I'm sure like the whole Zoom thing is weird and all of that, right? But the etiquette in terms of, you know, this, I know you guys identified yourselves by name, like when we were kind of figuring out like who was who and stuff like that. But when you start your argument, I mean, you kind of want to start it off with, you know, may it please the court, I'm Andrew Adams, I'm here representing, you know what I'm saying? And I thought you guys responded really well in terms of questions. Everybody spoke, you know, very clearly. I didn't have a hard time, you know, following, you know, what you were saying. And yeah, I mean, you know, thank you for all of the hard work that you put into your preparations.
Let's go to Judge Thunder.
Well, I'd certainly like to echo the exact same sentiments of Chief Justice and Justice Adams. For all of you, congratulations. This is, I hope that you can smile at the end of the day here and even throughout the weekend, because to get this to this point is a huge deal for all of you. And I was extremely impressed with all of you, all for different reasons. And I echo some of the points that were made out as far as maybe making a stronger presence known from the beginning. And perhaps that is something that is distinguishable with old and new school, but I think it is still something that should be warranted no less. And you'll find that no matter how you practice, as the Chief Justice had mentioned, to be able to, and Chief Adams, Justice Adams as well, of how introducing yourself in a certain type of way is crucial in being able to represent the tribe or whomever your client is, and make that so clear at the beginning. That really helps. I'd like to note for Paulina, I loved your demeanor. I know that out of the first gate, like, it's so been there, and you did a really great job. I want you to know that. And it was clear that you did have a great understanding of the case in front of you. Same for your partner, Eric. You did a great job. I felt that your transitions were very streamlined, and I appreciated that very well. And then for team 1027, Emily, you were such a strong speaker and forceful but respectful, totally to the Chief Justice's point. And I very much appreciated that demeanor. That will go far for you, however you want to continue. And Zachary, Kelsey, you were really tremendous in how you were able to keep your theme so strong, and how you were able to respond to the questions and jump right back in to where you were going for your path in how you were delivering to us. And so I really want to say I was very impressed with how you handled all of that and stuck to your guns on that that theme, which is very impressive. So thank you all. You all were tremendous.
Thank you. And Judge Brisbois.
That's why. I don't want to repeat everything that's been said. I agree with it all. I think the main things I want to say is that the level of preparation and hard work that you obviously all put into this came through in your performances, in your presentations. Everybody was very well spoken in the sense of being able to understand you. There was not a lot of verbal tics. There was not no mumbling or softness of voice, which from a judge's perspective is very, very helpful. That's something you want to remember and take forward with you as you go off into your practices after law school. The last thing I'd like to say is that remember how much effort you put into getting ready for today. Remember how much effort you put into marshaling your facts, your authorities, everything, so you could have it the tip of your tongue, the tip of your fingers. And I want to say, as you go forward throughout your career, your entire career, it's not going to get any easier. And I don't mean that to frighten you. I mean that to say that's the level of preparation that you're going to want to put into every argument in every appearance before a court that you make throughout your career, because that's the way you're going to be successful. And you've all demonstrated without limit the ability to do that today. And if you maintain that commitment and skill throughout your careers for each argument, each appearance in front of a court or tribunal, your clients are going to be well served.
And let's go to Justice Chairman Fox.
Hello, everybody. I didn't get a chance on the 10-minute little recess there, so I just want to first say to fellow judges and those who participated from that perspective, awesome job. Pleasure and honor to watch each and every one of you. Some of you obviously practitioners, and I didn't have any need for asking any questions. I was silent, and that's not very common for Mark Fox. But you know, I knew Andrew was covering everything for me, and I just had to just listen. So that being said, now to the participants, I want to say, similar to what others have said, you're well on your way in your lives, your careers. Obviously, you've done very well in law school. That's going to carry you forward, whether you win or lose this evening at the final round here or not. I'm telling you that you know, your careers, the enjoyment of law, and everything you've done, you've indulged yourself with, and you're committed to. You're well on your way for the rest of your lives to doing really well. So I'm impressed by your demeanors and everything that you've done out there. And good job, good job. Time is a premium with me. I don't get a lot of it, and usually on a Saturday night, I'm trying to do nothing at all. But this has honestly been a real joy. This has been a pleasure. And not only that, I was getting such an enjoyment out of listening that you brought me back 28 years, because that's how long it's been since I was in law school. And so thank you. Awesome job to everybody. But the participants, great job. You know, I have very little criticism. My scores are conservative a little bit, but that's just the way I am. And so good job. Law school, NALSA, everybody, UND, my alma mater. Awesome job. And I really enjoyed it, though. And Chief Justice, thank you. Thank you for leading the way through it all. It was really an enjoyment tonight. Thank you.
Oh, thank you. I know how busy chair's position is, and so it's a real treat to have someone in charge of a nation to give up their Saturday evenings. So we appreciate that as well. Let's hear from Justice Yellowhammer.
I too don't want to take up time echoing what everyone else has said, but congratulations to each of you. I can understand why you've made it to the finals. Team 1004, I really was impressed with your calmness. You both have a great demeanor. Ms. Noskova, it can't be easy being the first one starting out. So I think you were brave, and I applaud your courage. And Mr. Rolston, I really liked the way that you paced yourself, and you were very easy to follow. And again, I appreciate being able to kind of slow down enough. I know that you had a lot of ground to cover, but I think that it is important to slow down. And, you know, I practiced in public defense before I became a judge, and I always tried to tell a story. So even when, and this is not my area, that's why I was so quiet, but it's important that you have not just a roadmap, but those guideposts, right? That people can really follow along and come back to your main points. So I thought it was completely, you know, impressive, the facility you have with the case law and being able to come back to things. But again, slowing down and painting that picture, I think, is really important. Team 1027, I really echo what others say about your your strength and your presentation and your passion that really came through. I did like a lot the metaphors that you used about knocking on the door, or, you know, coming back to those things. That's very helpful in really keeping track with what you were trying to get across. So you're all winners. I think you'll be great lawyers, and I'm really glad to have been part of this. Miigwech.
And thank you. And last but definitely not least, Justice Seaworth. You can unmute yourself. Oh. There we go.
Okay, can you hear now?
Yes.
Thank you. It's been 38 years since I was in a moot court competition, and I have to give you all a lot of credit because the problem is more complicated and it was more challenging than the problem that I remember. And I think that's important because all of you have a unique style. I think your styles will make you good attorneys. And I think to have this kind of discipline and this kind of experience is going to help you be good attorneys for a long time. And that's what we really want to see, is we want to see people like you join the legal profession and make us all proud. And I think you all did that today. Thank you.
Do I hand it over to somebody now?
I could take over, Chief Justice. Thank you. I just want to say thank you to all the justices for your time, competitors, everyone listening. Thank you so much on behalf of UND NALSA and National NALSA. This means a lot to us and I can't express it. I just have one announcement. Please go to room, besides the justices, please go to the main competition room and they will begin the award ceremony at 7 or in 7 minutes, 7 o'clock Central Time. Thank you so much again for everything.
Yeah, thank you. And thank you to National NALSA and to the University of North Dakota Law School.
Thank you so
Stay
much to the justices, and thank you to NALSA and UND as well. We really appreciate it.
Yeah, thank you so much for taking your time and giving us this feedback. Really appreciate it.
Thank you.
Thanks, everyone. Stay safe.